Welcome to the O'Connor Elder Law channel. I'm your host, Melissa O'Connor. I'm a Florida-based attorney that does two things and I do them well. I help families with Medicaid planning and I do probate. Today I wanted to talk to you about transferring of real estate interests when one anticipates needing Medicaid for long-term care. I recently had a family that I was assisting with Medicaid planning in my office, and as we were reviewing all of the transfers that had taken place in the past 5 years, we discovered that about 3.5 years ago, a transfer was made to a grandchild. At that time, grandfather was living, and it was his desire to fulfill one of his legacy goals and transfer one of his rental properties to a grandchild. And then he passed away. Fast forward to the present day, grandmother has an Alzheimer's diagnosis and is in need of specialized care, long-term care, that we were looking to be able to help fund with a Medicaid application. And now that transfer of the rental home to grandchild is causing the family a little bit of a problem, or at least it's triggering a penalty period for grandmother for her Medicaid application. Essentially, what Medicaid does is when they see transfers like that, transfers of real estate with that were clearly gifts, they will assign what the fair market value of that piece of property was at the time of the transfer and use that as the value of the gift. Then they will divide that by their penalty divisor and determine the number of months that the Medicaid applicant, and in this case grandmother, must sit out on the sidelines and not be able to qualify for Medicaid, and the family must cash pay for grandmother's care until such time that penalty period is up and grandmother can then have her Medicaid application processed and approved. So the family realized, oh, yep, that transfer happened, and we went through various thoughts and ideas to see how we were going to deal with this. And ultimately, it was clear the grandson was not able to pay fair market value for the home that he received from grandfather, that gift. It was a generous gift and not something that he had the ability or resources to repay at that time in his life. So the family decided, okay, that's happened. That was grandfather's desire. That was his goal for his legacy. And we came up with another plan, another strategy in place where we were going to be able to fund the penalty period, and grandmother's application to Medicaid can still be submitted and processed, and we had a plan in place. So I just shared this story with you because I know that there are many families that would like to make certain transfers of certain properties, all good and well-intended desires to fulfill their legacy and to generously give to the next generation. But when doing that, one must consider if you will need long-term care needs that would involve a Medicaid application, because if so, I encourage you to reach out to an elder law attorney to help you do that legacy gifting, while at the same time doing it in a manner that would be Medicaid, that would be compliant with Medicaid's guidelines, so you won't be suffering through a penalty period. Had grandfather anticipated his wife's medical needs and the future application for Medicaid, I would have been able to help guide him through alternative ways to give his grandson, to ensure his grandson had the gift that he so desired his grandson to have, that would not have impacted his wife's Medicaid application in the future. I encourage you, if this information has been helpful to you, to like and share with others. And as always, thank you for joining me.